Hello, everyone, and welcome to the webcast. My name is Christine Dorsey Davis. I'm the Executive Director of the Ohio chapter of the American Planning Association, and I am your webcast moderator. Today is Thursday, November 5th, and we will hear the presentation, Land Use Law Update. Get my next slide here. Here we go. Okay. For technical help during today's webcast, you can type your questions in the chat box found in the webcast toolbar to the right of your screen, and you can also type your questions in, your content questions related to the presentation. You can type those in, again, the chat box found in your webcast toolbar. We will answer those questions at the end of the presentation during the Q&A. Coming up next on your screen is a list of our sponsoring chapters and divisions for 2020. Thanks to all those participating sponsors for making these webcasts possible and free to members. Today, we are sponsored by the Mid-Atlantic Planning Collaboration, which is a joint venture of the Maryland National Capital Area, Virginia, and West Virginia chapters, along with the Maryland Department of Planning, Maryland Planning Commissioners Association, the Rural Planning Caucus of Virginia, and West Virginia University's Land Use and Sustainable Development Law Clinic. Shh. Sorry, guys. I have friends with me today that I normally don't have. The intent is to address topics that may be of interest to people involved in planning at all levels across multiple regions. So thanks to all of you for this group of folks coming together for that. Hey, head over to ohioplanning.org/planning webcast for a list of all of our upcoming sessions, which you can see right here on our screen. We're adding them daily, so be sure to check back. Today's webcast has been approved for 1.5 CM credits, law credits, and you can go ahead and log those credits by heading over to planning.org, log into your MyAPA account. From my understanding, there is an issue with the search function right now. If you type in the event number or the title, it's not working. So you might need to go through email me if you have trouble, or email APA if you're having trouble finding it. I'm not sure if that glitch has been fixed yet. I know they're working on it. So it's not you if you can't find it, but be sure to get those credits logged. And like us on Facebook, Planning Webcast Series, it's where we post all of our upcoming sessions as well when they're getting ready to post, and any changes that we might have or cancellations. And subscribe to our YouTube channel. We post all of our webcasts there. We record everything, so be sure to subscribe. That's it for all my housekeeping items. I am now going to turn it over to Jared Anderson to kick things off.
All right. And we'll go ahead and get things started. Actually, Jesse's going to go ahead and start us off here.
Well, thank you all for coming today for our land use law update. As you heard, this is part of the Mid-Atlantic Planning Collaboration. This is the first CM webinar that we are doing. We're starting out with a series of 8 webinars that you can see on the next slide. We think that it's going to be a really good series, and we are going to start doing this as a regular thing. You heard our partners in Virginia, Maryland, West Virginia, and I want to thank all of those partners. Thank the Ohio chapter of the APA for hosting us. And as you can see, we've got ethics next week. And then we have several of these upcoming webinars will qualify for law CMs as well. Although I guess everybody on this webinar already has their law CMs for the year. But there are going to be some really great webinars. I highly recommend all of them, but particularly sign ordinances is going to be really good. Talk about legal issues with green energy. A lot of really hot issues like broadband, equity planning, better public engagement, and the Planner's Toolkit. So we're covering a broad spectrum of really pertinent topics. You can see our website there at the bottom, but if you Google Mid-Atlantic Planning Collaboration. You can get to the website, sign up for the webinars. So again, thanks for coming today. If you look at the next slide, here's what we're going to talk about today: some regulatory takings cases, small cells and telecommunications, FOIA open meetings, and COVID. We're going to talk a little bit about signs. We do have a full hour and a half on signs coming up. We're going to talk about the Religious Land Use and Institutionalized Persons Act, which there are always a lot of cases on that. And short-term rentals has had some interesting cases come out in the last couple of years, and a lot of things going on with local governments. So we're going to talk about some cases there. Before I turn it over to Jared to start talking about regulatory takings, I did want to give our standard disclaimer that this webinar is for educational purposes. Nothing that we say today is legal advice or intended to be legal advice. And when we answer questions later, we are happy to answer questions, but we also give the caveat that we don't know all the facts and we're not giving legal advice. So I'm being a typical lawyer there. And I should back up before I turn it over to Jared and introduce myself. I'm Jesse Richardson. I'm a professor of law and the lead land use attorney at the West Virginia University College of Law in the Land Use and Sustainable Development Law Clinic. Our clinic is very unique, only 2 land use clinics in the country at law schools. And we're actually even more unique than that because we do technical assistance to local governments on planning issues. We draft comp plans, we draft zoning ordinances, subdivision ordinances, address all kinds of land use issues. We also look at land conservation and wastewater issues. We have, I'm losing count here, I believe we have 6 attorneys. One of those attorneys that you're about to meet, Jared Anderson, is also an AICP planner, and we also have an AICP planner on our staff. And we do work all across West Virginia, and sometimes we'll venture into Maryland or to other states. And Jared and I are land use law nerds, so I hope you enjoy our presentation today. And with that, Jared's going to start you off at the United States Supreme Court with some regulatory takings cases.
Thanks, Jesse. Yeah, again, my name is Jared Anderson, and I am an attorney in West Virginia.
Hey, I think you muted yourself. Oh, there you are.
Oops.
Perfect.
Okay, sorry about
You're
that.
good. No worries.
Okay, all right. Yes, my name is Jared Anderson. I work with Jesse at the Land Use Law Clinic, and we are very excited about the Mid-Atlantic Planning Collaboration and all the partners, including the Ohio chapter of the APA and all of our other partners. So this is really exciting for us. And so I'm going to start off with a case that some of you all may or may not have heard about. It's a case from a few years ago under the Supreme Court of the United States, and that is Murr versus Wisconsin. And this case is a takings case, but it really came down to whether or not the property how it's defined is really kind of at the crux of the case. Just as a little bit of background, the Murrs owned property on the St. Croix River in Wisconsin that river kind of divides, at least in part, divides Wisconsin and Minnesota. The MERS had owned the property. I think it started with the parents, and then the siblings owned the property. There were two properties, at least in the MERS minds. There was Lot E and Lot F, and those two properties were contiguous, and they were under common ownership by the MERS. And the MERS had a cabin on Lot E, I believe. Now, one of the things in the facts of this case that is important is that the MERS, again, owned both lots, and the lots were contiguous. The MERS tried to sell off Lot F because they wanted to use the funds to kind of revamp the cabin on Lot E. And the jurisdiction in Wisconsin said, well, since these lots E and F were substandard for development, the local ordinance required that both of those lots be merged. And what this meant in practicality was that lots E and F could not be sold separately. The MERS argued that Lot F is not worth anything now. We want to sell it off. We can't. This is a taking. The state said, no, the way you've got to look at it is that this is one lot because of the merger requirement. So under this case, SCOTUS sort of announced a three-part factor test in identifying the proper unit of property. That's sort of, again, what the issue was. Do we treat the MERS property as one piece of property for takings analysis, or do we treat lots E and F as separate? And so the SCOTUS came up with a three-part test. The first thing they looked at was treatment under state and local law. And in this case, state and local law said that there's a merger provision, there's a merger ordinance in place, and that if the lots were substandard for development and they were under contiguous and under common ownership, then the merger provision applied. SCOTUS also, in this case, stated that merger provisions were a valid land use tool. So they looked at the first factor was important. The second were the physical characteristics of the property in question. And in this case, they were fairly narrow lots. My understanding, they were in the riparian area close to the river. That part of the St. Croix River was had been there had been regulations in place in that area for many years, and so it shouldn't have been a surprise, at least from the court standpoint, it shouldn't have been a total surprise that there would be limitations on that land. And I think it was pretty hilly as well, steep topography. And then the last part is the value, and just to look at the value of the property in question. And so what we had was a 5-3 decision. I believe it was Justice Gorsuch had just been put on the bench, and so I believe it was Gorsuch that didn't vote on this case. But the court said that Wisconsin was correct in viewing the parcels as one through the merger ordinance, and that there was no taking in this case. What we saw, though, and we've seen this in the past and in other cases, is that in response to a decision, the legislature acted. And in this case, the state of Wisconsin's legislature created legislation that limited the authority of local governments and state agencies to enact lot merger provisions. So that was an interesting case. The other takings case, again, this is at the highest court. This is at SCOTUS. This is 2019. You all may or may not have heard of the Nick v. Township of Scott case. Scott Township is, I believe, in eastern Pennsylvania. The township enacted an ordinance that required cemeteries to be open and accessible to the public. The ordinance also enabled a township officer to enter the property to determine if there was a cemetery. The property owner, and I believe it was Miss Nick, challenged this case as an unconstitutional taking. And so what we see here is it is a takings case, but one of the important imports of this case is that between 1985 and 2019, 1985 being the Williamson case, between that time, for takings cases, private landowners had to exhaust all state-offered venues for mediation before seeking action in any federal court. What this meant is that during that time, it was very difficult to take takings cases to the federal courts because you had to exhaust all your options through the state courts and state judicial system before you could take it up. And what SCOTUS said in this case, and this was a 5-4 decision, was that no, the exhaustion requirement that was established in 1985 for takings cases has been overturned, so that is no longer the case, that you need to kind of go through. And in some ways it makes sense, just thinking of the constitutional issues. Other constitutional issues that aren't takings cases didn't have that same requirement. And there's arguments for and against that. Obviously, if it's a 5-4 decision, there's several justices that felt that Williamson should be kept in check. So that was the important thing with the Nick case. We're going to change gears here quite a bit, actually, and talk about small cells. And it starts off with the September 2018 FCC small cells declaratory ruling and order. It was I think for those that have been a part of or are interested in small cells and telecommunication facilities, it seemed like it was probably about time for the FCC to provide guidance on small cells. How, if at all, were they going to be treated differently than your normal cell tower technology, cell phone facilities? And so in 2018, in September, the FCC provided the order. And I think the general gist of the order was to ensure smooth and clear deployment of 5G technology across the country. I use the term 5G and small cells, those terms interchangeably. It can get very technical very quickly, and we're just kind of skimming the surface here. But part of the FCC ruling and order was to kind of define what small cells are. But the other things that the FCC tried to do, and these are more general thoughts through its September 2018 order, was to ensure that there was much faster network speeds for broadband consumers. They acknowledge automated car technology, and also acknowledged home automation, telemedicine, and other essential technologies as the reason for kind of ensuring that there's deployment of 5G technology across the country. There's a lot of caveats with that, and depending on where you're situated. I know in West Virginia, 5G isn't something that we're seeing a whole lot, but I'm sure in other places you're probably getting these questions or have already entertained a lot of these questions about siting and applications and all of the things that might come up when you're looking at 5G or small cells coming into your community. Oops. So there's 3 main areas with the small cell order that are really things to think about if you haven't thought about them already. With the order, it identified actual costs that the FCC considers reasonable for applications. It could be, they identify, I think it was for recurring fees for maintenance and whatnot. It was $270. I think it was $500 for an application. Again, these aren't, these are what the FCC considers reasonable to cost, but they actually outline in the order a number, a number what, and that's what they say is reasonable. Doesn't mean that a community can't charge more for considering these certain applications. It just means that's what the FCC has considered reasonable. The other thing, restrictions. So the FCC, the Commission, tried in their order to balance the deployment of 5G across the country while still allowing local governments to protect public safety and quality of life. That was again what they had stated in the FCC. The other thing, the last thing that really came out of the 2018 order was that that there was more shot clocks that were established. Anyone who's dealt with cell towers, cell phone facilities knows, probably knows about the shot clocks. Well, there's more shot clocks now. And it can get kind of confusing, at least for me it is. It's for small cells, it's either 60 or 90 days, depending on what kind of application. One thing that wasn't in the FCC order, and one thing that the industry was, at least some of the industry wasn't too happy about, was that there was no deemed granted language for small cells. The deemed granted language being what you can see a corollary in traditional cell tower regulations. If the local government doesn't address an application within, or make a decision on an application within a certain amount of time, that application is deemed granted. There was no such language in the 2018 FCC ruling. So what happened after 2018? A lot of, again, most of these are major cities, but a lot of cities around the country were not at all happy with the FCC ruling of 2018. They thought that some of their power had been, and some of the way that they wanted to regulate themselves had been kind of stripped away by the FCC, and so a lot of communities across the country, again, mostly major cities, but on the East Coast and West Coast, filed suit. There were suits in at least a couple circuit court of appeals districts, noticeably the 9th and 10th. They consolidated those cases into the 9th Circuit, and we have the city of Portland versus the United States, which was heard, I believe, late last year, very early this year, and by the 9th Circuit. This was a 3-member panel of the 9th Circuit that heard this case, so it wasn't an en banc hearing, which you wouldn't expect. But the 3-member panel in the 9th Circuit largely upheld the FCC order. There was very little that they sort of said was improper or needed to be changed. They said that the FCC order needs to facilitate the rapid deployment of 5G and that it's reasonable. They being the court, also upheld the charging of the costs that were the reasonable costs that were associated with the 2018 order of what was presumably reasonable for a community to charge for these applications. And they also upheld the shot clock, or the 2 shot clocks that were mentioned in the FCC order. There was one point that the court disagreed with the FCC, and that was that local government aesthetic requirements are not preempted if they are, and this is got to meet all three of these, but the aesthetic requirements, if they are reasonable, no more burdensome than those applied to other types of infrastructure, cell towers, objective and published in advance. So the Ninth Circuit did say that's okay. So there are some things, much like cell towers, that local governments can address through their ordinances. And I will say before I leave this subject that prior to the City of Portland case in the DC Circuit Court of Appeals, actually heard a case. There was a point in the 2018 order that suggested that NEPA and the National Historic Preservation Act were not required in cases for 5G. And the DC Circuit Court of Appeals said no, NEPA and the National Historic Preservation Act are applicable in small cells, and there's no reason why they shouldn't. So there was another case on this in the DC Circuit Court prior to the City of Portland. So there were a few things from the SCC order that have been sort of contested. So now we're going to move on to what I think is it's my favorite case, partially because of the content and partially because it's from my home county, Loudoun County, Virginia, just outside of DC. This was a Fourth Circuit case, so some of you all this would be applicable to, but others outside the Fourth Circuit, maybe not, not so much. But this is a social media case, and Jesse and I, when we were talking about it, we said this could be very important for planners to understand and to realize, because there's definitely a practical element to this. So as a social media case, the board of supervisor member, and in Virginia, the board of supervisors kind of like the county commission, their elected position, kind of oversee county government. What had happened was there was, I believe, a school board meeting where the board of supervisor was in attendance, and where Mr. Davison, who's the plaintiff in this case, where they kind of had some discussion points during the meeting back and forth, and then they moved that discussion kind of into Facebook, into social media. And what had happened was the board of supervisor member I think put a post on her Facebook page, a comment, and then the citizen replied to that, and the board of supervisor member just kind of deleted the entire comment, including her language, and banned the citizen from her social media page. The citizen sued, and it was only temporary. She I think she probably slept on it, woke up and was like, that's maybe not a good idea. So she unbanned him from the social media page. And this is very much a fact-specific inquiry legally. And that is that the citizen sued and claimed that the board member violated his First Amendment and due process rights by blocking him from her Facebook page. And it was important for the Fourth Circuit to look at and answer the legal question of whether the board member's Facebook page constituted a public forum under traditional First Amendment law. And it had been, there was no established case law prior to this. But what they came up with was that the chair's page, the board of supervisor members page, bared the hallmarks of a public forum. And I'm going to go to the next slide and kind of explain. And I think that this is really one of the main things to take away from this case. And the Fourth Circuit affirmed that the board member created and administered the Facebook page. And I've added emphasis here because I think this is really important. On the Board of Supervisors Facebook page, she states that she wants to hear from any Loudoun, that's the county, any Loudoun citizen on any issues, requests, criticism, compliment, or just your thoughts. That to me was fairly dispositive. It was not her personal page. She had access, and I believe maybe one other person had access. She didn't use the Facebook page for personal reasons. There was maybe, out of all the comments, there was maybe one or two comments that might be construed as kind of personal comments. I think she was happy. She announced on that page that she was happy to be an organ donor, something like that. But the page was, it was meant for there to be transparency and to be an engagement of the citizenry with her through social media. And they saw it as a public forum. The court said that because she allowed other viewpoints and allowed other comments, and because she didn't like what Mr. Davison had written, she engaged in viewpoint discrimination, and she violated the plaintiff's freedom of speech under the First Amendment. And because of the way her Facebook page was situated and sort of put out as a tool of governance, that she wasn't entitled to block the plaintiff or any citizens from commenting on this particular Facebook page. I think it's important to note that I'm not suggesting that what the court was saying, that you can't have a Facebook page if you're an elected official. I think what bears in mind here is that it is, if you start to see elected officials, or even your own, maybe you're administering a Facebook page for a comp plan update or zoning, trying to get public input. You need to be careful about what the intent and how this is viewed. These social media pages are viewed and how they're used. I think that this was fairly clear that it was not her private page. However, I think that there's other cases that may not be so clear, where you really do have a mixture of personal, you're happy that your cat turned 8 years old, or you're showing your macrame or whatever, and then you talk about the agenda or you talk about zoning. That's a little bit more difficult. So this is an important case to think about, because social media, as you all probably are painfully aware, it's become more and more important as we move forward. All right, so I'm just going to go through. I don't have anything case-wise, but one of the things that I thought was really important, especially in these last couple months, is how we as planners, even if you're on the private side, and engaging with the public sector, or if you're a public planner, how we've dealt with meetings and how we've dealt with moving things forward, right? Every state has some version of the sunshine laws. They're all different, but they all, I think, for the most part, they all have the same primary concerns, right? It's transparency, allowing the citizenry to actively participate in the meetings, having a record of what was discussed, who was there. Those are all, I think, central tenets to open meetings, sunshine laws, whatever you want to call them. And one thing that happened fairly quickly, at least with Jesse and I in our group, was and I'm sure it was the same with you all, is that everything shut down, right? Everything shut down fairly quickly. We didn't have a ton of time, but things still go on, right? And so, and this is a rhetorical question, and if you want to answer it in the Q&A session, that would be fine. I'm a planner, so I'm all ears. But what problems, if any, did you encounter with respects to meetings during the pandemic? Was it difficult? Did your state even allow meetings by electronic means? Were there certain caveats? Did there have to be an executive order? Those are all things that come into play. And so the next question is, how did some states deal with compliance? I know in West Virginia, we were lucky enough to have the language in place to have meetings entirely by electronic means. One of the main things being that as long as we had a quorum and as long as everybody could hear one another via speakerphone or via Skype, then it was fine. But that's not everywhere. And so, how did we deal with it? Is there any lessons learned? One thing that we were very concerned with early on was we deal with very rural communities in West Virginia where broadband is not there or is in very short supply, and could we have Zoom meetings? And I think for the most part, the communities that we've been working with have been resilient and have figured out ways to either call in or have the meetings via phone or what have you. So it's worked out pretty well. But I think the important thing is how do we move forward? Do we need to relook at our open meetings laws and make them more flexible, or is it important or imperative for us to, as soon as it's safe, to go back to face-to-face meetings? I'm kind of split on it. I realize how important face-to-face meetings are in some communities, and so that might be important. But I just thought it's good to think about some of the struggles and some of the problems, and then try to figure out ways to remedy those and to look at the laws and existing regulations for open meetings and COVID-19 and beyond. FOIA, kind of similar things. Some states suggested invoking extensions to respond to a request under existing statutes. Some communities cited an executive order and this is going back to the spring, cited executive order to suspend response times. DC expanded the exception under their ordinance to include days of COVID-19 closure. And so moving the FOIA strategy, or the FOIA strategies moving forward, I think are fairly straightforward and common sense. Be very clear and proactive with the requester. Don't wait till the end, right? Sometimes we're not going to get a requester that wants to budge at all. They want to stick strictly to the statutory allowances. So you might just have to work with what the statute allows. But if there's any way that if you could work with them, and don't wait till the very end, be very upfront and very transparent. And then as a last point, talk to legal counsel and figure out what the best way is moving forward. I'm sure there was a lot of headaches across the region with FOIA during the last several months, and it's something that we need to continually try to adjust and address in a meaningful way. I'm not going to spend a lot of time, and I just want to put a plug in for our webinar on signs with our coworker Whitney Morgan. It's going to be a great session, and I highly recommend that you listen to what Whitney has to say on signs. It's not easy, as some of you may know. In fact, I've got the first question: what is a sign? It's one of those questions that topically or on the surface, we can all say, this is a sign, this isn't a sign. But then when you get into the nitty-gritty of it, it becomes a lot more difficult to really figure out the nuances. Just one really quick thing about the Reed case, and I'm sure Whitney will talk about this, is that we really need to focus in on whether the zoning regulations, whether the sign regulations are objective and not based on content. When we start getting into content-based regulations, you start getting into difficult waters legally in most cases. And the Reed case was a Supreme Court case from a few years back. But if you're interested, please join our webinar with the collaboration, and I'm sure you'll learn quite a bit. So I have I think this is the last couple of slides, so I'll turn it over to Jesse. This is actually both a First Amendment sign case and a RLUIPA case out of the First Circuit up in the northeast part. The town denied the permit for an electronic sign because it would detract from the rural character of the Route 3 corridor. So there's the church, and then there is the Signs for Jesus, which is a nonprofit that was going to erect an electronic message board sign for the church in Pembroke. The town's ordinance lays out the criteria to determine whether a sign is an electronic changing sign, their objective criteria. It's not that the church wasn't allowed to have a sign where they were located in the zoning district, but they weren't allowed to have an electronic sign in that specific zoning district. And what the court found, the First Circuit, is that and this probably isn't a surprise to most planners, but the First Amendment doesn't guarantee a right to the most cost-effective means of distribution when we're talking about signage. Okay, and what the court, I think, continually went on about was they can have a changeable copy sign there. It's not that they can't have any signs, and that they can essentially do the exact same thing with the signage that is permitted under the zoning than they could under the electronic copy sign. So they weren't, the First Circuit wasn't swayed under the First Amendment claim at all. The second thing, and Jesse's going to get more into RLUIPA here shortly, but the second claim was under RLUIPA. They had two claims: under the equal terms provision, and then under the substantial burden provision. The church says, oh, there's Pembroke Academy, which is a school, and the Department of Transportation. They have electronic signs in the zoning district, and the church used them as comparators. The court said, well, the school is part of the state essentially, and the Department of Transportation is, and so they're not subject to local zoning regulations. So those aren't good comparators. So they kind of dismissed that prong of RLUIPA, and then they also contended that the church contended that it was a substantial burden. And the court basically said, requiring the church to continue using manually changeable non-electronic signs is hardly an oppressive imposition on the church's religious exercise. So they didn't buy the substantial burden provision under RLUIPA as well, because they could still have signage and that could essentially do what they were hoping to do. So I think that is it for me.
Thanks, Jared. Yeah, I'm going to talk about 3 more RLUIPA cases, and then talk about a few short-term rental cases, and then we'll open it up for questions from y'all. RLUIPA, as Jared talked about, Religious Land Use and Institutionalized Persons Act. I'm a little bit surprised that there are still so many of these cases out there, and a lot of them, frankly, the court doesn't have a lot of difficulty with them because the facts are just so bad. In this case, and there are a lot in Maryland for some reason, a lot in Baltimore County, Maryland, and they're all in the Fourth Circuit, although, and Jared talked about the Davison case in the Fourth Circuit. Even though you may not be in the Fourth Circuit, those cases may be influential in your circuit as well. So it's a case that you should look at to consider in your jurisdiction. So in this case, the church, Redeemed Christian Church of God, purchased some new property to accommodate their larger congregation. And the zoning district allows churches, and the church purchased this particular property, among other reasons, because it's in the sewer envelope, because they were going to need some sewer for their larger church. But the county, even though the property was in this sewer envelope, which is where sewer is available in the county denied the church's application to upgrade their water and sewer to accommodate their larger congregation. So the church filed suit under RLUIPA. And the first thing that the county did was move to dismiss the claim, saying that water and sewer approval is not a land use regulation under RLUIPA. And one part of RLUIPA, the part of RLUIPA that affects most of you here today, is that part that talks about restrictions on land use regulation. And so if we go to the next slide, the court first, pretty quickly and without a lot of discussion, said that water and sewer approval is indeed a land use regulation. And so this is covered under RLUIPA. And the church also, or the court also said that the church has stated a valid substantial burden claim under RLUIPA. And that substantial burden was that the county's denial, or at least according to the court, the county's denial intentionally overcrowded or provided insufficient space for the religious organization. And that overcrowding and that providing of insufficient space placed a substantial burden on the exercise of their religious faith. And the court said, and this seems also somewhat intuitive, that when the church purchased property within the sewer envelope, the church had a reasonable expectation that water and sewer applications would be approved. So that case is not over. That just meant that it's not dismissed. But the court's language was fairly strong and signaled that the church had a pretty strong case going forward. The next case, I think, is very fascinating. Very recent case out of Florida. And when the court leads off your RLUIPA case with some quotes from the Bible, the local government is in trouble. And that's what the court did here. They led off with some quotes from Matthew and from James. And the reason the court did that, if you look at the next slide, this is a little different for RLUIPA cases. It's not a church that's going in. This is a transition home for no more than 3 people at a time. But it could include registered sex offenders. So when the church was starting this home, they contacted the county planning office, and the county planning office told the church that this particular home, that the use permitted was a family care home with up to 6 unrelated people, and that this transition home for no more than 3 people qualified as a family care home. So the church purchased the building. They operated this transition home for a year and a half and had no problems. And then the neighbors found out that there were some registered sex offenders there, and they complained. Upon receiving the complaint, the county issues a notice of violation and said that the church was operating a boarding house and that the boarding house is not an appropriate or allowed use in that zoning classification. But when we get to the next slide, that's when the local government starts to dig their hole a little deeper. 4 months later, they went ahead and apparently because they saw that this home came within the definition of family care home and perhaps shelter home, they went back and amended the ordinance to remove family care home and shelter home as permitted uses in the district. And the county director of planning kind of put the final nail in the coffin here when they testified that not only could this transition home not locate in that particular zoning classification, but there was nowhere in the county that the group could operate its transition home. And so the court found that this was a substantial burden on religious exercise, and that the county failed to show that the burden imposed is the least restrictive means of furthering the compelling interests. So I put that quote up that the court started the case off with, and I'll just mention the first part of it. Lord, when did we see you hungry or thirsty or a stranger or needing clothes or sick or in prison and did not help you? And the point that the court was making is that this transition home is a religious exercise. It is part of their religion. And by essentially prohibiting the home throughout the entire county, that puts a substantial burden on religious exercise. And that was a final resolution of the case unless it is appealed. The next case is a little more of a plain vanilla RLUIPA case, and gets to the heart, I think, of a lot of RLUIPA cases. In the particular zoning classification at issue here, the conservation district, certain assembly uses, public assemblies like public schools and other similar type uses, were allowed of right, but a church required a special exception. And when the church applied for a special exception, the county denied it and said that the parking and the gymnasium were inconsistent with the zoning provisions. Well, some of you, if you're still with us, are probably thinking, don't public schools have parking and gymnasiums? And that's what the court said. And the county had filed for a motion for summary judgment, asking the court to rule in their favor as a matter of law. The court rejected that motion for summary judgment and said that here the church had stated a claim for a substantial burden. And this is the first time we're going to talk about, in addition, the church had stated a claim for discrimination. Because, like I said, you can have a school in this particular zoning classification, but you can't have a church. That seemed to be discriminatory. When you add into that some members of the board had made derogatory comments about a mega church and homeschooling, the court said that was enough for the court to say this needs to go to trial. I'll mention one more RLUIPA case before we move on to short-term rentals. There's a case out of Stafford County, Virginia, where Stafford County had denied an Islamic church the right to build a cemetery on land that the church had purchased to put a cemetery on. The Justice Department filed a lawsuit against Stafford County in June, and that case was recently settled, and Stafford County changed their zoning rules to allow cemeteries and to allow the Islamic cemetery in that area. So cemeteries, transition homes, food banks, lots of different uses can come under RLUIPA. So now let's talk about short-term rentals. And short-term rentals are perhaps not as hot an issue as they have been in the past, but I'm sure they're going to come up again in the future. This is out of the Ninth Circuit Court of Appeals, but it's a very important case that a lot of local governments filed friend of court briefs in this case. The International Municipal Lawyers Association filed a friend of court brief. Santa Monica, California, like a lot of local governments, had an ordinance that regulated short-term rentals. And in this case, the short-term rentals had to be 30 consecutive days or less, and had to be a home sharing arrangement where the resident stays on site with the guest. And they also had some other obligations on the platforms. The platform had to collect a transient occupancy tax, disclose listing and booking information regularly, refraining from completing any booking transaction unless the property was licensed and listed on the city's registry, and they could not collect or receive a fee for facilitating or providing services ancillary to a vacation rental or unregistered home share. The platforms like Airbnb filed lawsuit alleging that the ordinance violates the California Community Decency Act and the First Amendment. We're, of course, more concerned about the First Amendment claims, and the next slide shows what the claim was, that the Airbnb said this is a content-based burden on commercial speech. And the court said, no, this does not target conduct with a significant expressive element. Merely booking transactions on a website is not expressive. In addition, the ordinance does not have the effect of singling out those engaged in expressive activity, i.e. advertising. Therefore, the court dismissed all of those claims. And that, I think that case may well be appealed, and it's an important case for local governments as they try to figure out how they can regulate short-term rentals. Just a few more short-term rental cases that I thought were extremely interesting. Wallace versus Town of Grand Island out of New York. Again, New York, and this is pretty typical of Grand Island, prohibited short-term rentals in certain districts, except when the owner also resides on the premises. The plaintiff here, Wallace, had bought a single-family home for the express purpose of listing it on Airbnb before this ordinance was passed. And so the plaintiff first said, I'd like to get an extension of the non-conforming use amortization, where Grand Island had said, this is a non-conforming use, but will allow you to continue the use for 1 year prior to you having to terminate it. Grand Island denied that. So Wallace then filed a regulatory takings claim. And the court here said, no, this is not a taking. It reduces the value of the property, but that's not enough to show a regulatory taking. I'll also note that New Orleans has a similar case where the court, in looking at the New Orleans regulation, said that banning certain types of short-term rentals was also not a taking. The next case kind of shows the opposite side of these issues, and this is kind of a crazy case. Zatari versus City of Austin. So Austin, Texas created certain classes of short-term rentals, which are similar to the classes that a lot of local governments are segregating at this point. Owner-occupied is the owner there with the renters. Not owner-occupied, and then part of a multifamily residential use. If it was not owner-occupied, no more permits were going to be issued for those non-owner occupied, and all non-owner occupied rentals must cease as of April 1, 2022. Now, the next part of the ordinance was the part that really raised some eyebrows, and I can certainly see what types of issues that they were getting at, but the court apparently did not. The ordinance, in the words of the court, banned broad swaths of assembly. People could not assemble at these short-term rentals after 10 p.m. And I assume that would be outside. Outdoor assemblies of more than 6 people were banned at any time. And use of the property by more than 6 unrelated adults or 10 related adults was prohibited at any time. And I think everybody that's on this webinar can probably sympathize with the parties, the noise, the garbage, the things that are going on. But the plaintiffs here, the property owners, filed a lawsuit saying that it violated Texas constitutional provisions. And in this case, the state of Texas intervened and said that the ban on type 2 was a regulatory taking and a retroactive law. And on the next slide, you can see that the court also didn't take too kindly to this. The ban on type 2 rentals was unconstitutionally retroactive because it served minimal public interest, if any, and significantly impaired fundamental property rights. And I think the lesson from this case is to set out a purpose clause, just like you do for your adult uses. Why are you enacting this ordinance? Do you have any evidence to support what you're doing? Here, the city had never issued any citations. And I know the clients that we've worked with, the police have issued lots of citations. And the court said short-term rentals are just as residential as owner-occupied homes. It results in a loss of income for owners relying on this. And in Austin, these short-term rentals have been an established practice and a historically allowable use. So the court found that that was unconstitutional. The restrictions on assembly are more problematic, and the court said there was no regard for peacefulness or purpose, so they also violate the Texas Constitution. So that's a case I think local government should really pay attention to and make sure you have evidence for the regulations that you're imposing. So the next case is one of my favorites, and I really recommend anybody who deals with short-term rentals should read this case, because the judge went on to quote lots of land use law treatises and basic land use principles that a lot of planners, I think, would identify with. And I like this case too, because in West Virginia, the legislature has passed a statute that seeks to ban any regulation of short-term rentals. And this is one way that I think communities in West Virginia can kind of get around that in a legal way. Smithfield Township defined family as 6 persons living together, as many as 6, as a single, permanent, and stable nonprofit housekeeping unit. So the court said, and again, the court really backed up their opinion here by going through the land use principles, court cases, treatises, and talking about the definition of family. And family was not intended to mean one family this week and a different family next week. It meant a permanent and stable and non-profit group. The court upheld that definition and said that it permitted the prohibition of short-term rentals in those single-family classifications. So you might want to think of the definition of family as one way of going at that. The next case is very similar, and it is also out of Pennsylvania. And that court also in Pennsylvania said that a single housekeeping unit also denotes something other than a transient short-term rental situation, and that it was better classified as a transient business enterprise, not a single-family home. And the court in that case focused on the term single housekeeping unit. And that is all that we have today for you as far as an organized presentation. Again, we thank you for your attention today. And we look forward to any questions that you might have. And
Wonderful. Yeah, folks. Oh, go ahead.
we will turn our cameras back on and come back to life so that we can see you, or at least you can see us.
Right. Okay. Yeah, we have some good questions coming in. Let's see what we can take care of here in the next 15 minutes. Okay. So our first question, let me get my screens here. This is going to have to do with, here we go. Okay. The City of Portland v. United States. In one of your slides, I think it's on page 11, at least of what I'm looking at, it's one point the court disagreed with the FCC is that aesthetics requirements are not preempted if they are no more burdensome than those applied to other types of infrastructure deployments. So the question is, what is considered other types of infrastructure?
I guess that's me, Jesse, huh? It's a great question. I think that I guess one thing that would come to mind right off the bat would be other cell tower regulations infrastructure. That's one of the things that we got from the 2018 order, was that we weren't quite sure how the FCC was going to treat small cells. Were they going to treat them exactly the same as your traditional cell towers from a regulation standpoint, or were they going to treat them differently, and if so, how? And so I think part of that, the Ninth Circuit decision and where they kind of were trying to make this aesthetic requirement kind of balancing was for me, the first thing that comes to mind is just general cell towers, and how if you've got stealth design requirements, or you've got co-location requirements, that they'd be similar, even though the FCC is kind of looking at small cells and traditional cell tower facilities a little differently. So that's my best guess. I'm not really sure what other infrastructure they were contemplating.
Yeah, I would think anything like electrical utilities, telephone utilities, and I would think that you're probably generally okay as long as the aesthetic requirements are very broadly applicable instead of just applying to small cells.
Okay. This next question is in regards to Davison v. Randall, which is that social media case. I had this question too. Is the Board of Supervisors public page, is it as an elected official, or is it their personal Facebook page? And does it make a difference?
Yeah, well, and this was kind of the fact-seeking inquiry that the court made, was that this was a difficult one, because it was the Board of Supervisors, it was her name, Board of Supervisor Facebook page, and it was operated mainly by her. It wasn't like the Loudoun County Board of Supervisors Facebook page and she was the one on it. It was Miss Randall, Board of Supervisor page. And so that was kind of tricky, because there's a couple different levels. One is Facebook's a private company. They had to look at that analysis, and is that a public forum? But they also had to see, and this is where the courts, I think, will have to look at each case individually to see, does this have the bearing of a public forum? And in this case, they said the fact that she called out and asked for comments, the fact that she's kind of in her, I think in her title said Board of Supervisor member, Miss Randall, she's an elected official. And so they said that bears the hallmarks of a public forum is what they came down with. But again, like I said, there might be a case where it maybe not so clear. And that's where it might be a little tricky, is when you start really kind of, talking about, I said macrame, you talk about macrame and you talk about agendas on your same page, that I think is a lot trickier. So it's a very interesting case.
Yeah, I would
Jesse?
recommend, if you want to do this, to have a private page where you restrict access and you restrict the discussion on that page to non-public official discussion, like macrame. And then if you want to have a Facebook page as member of the Board of Supervisors, then have that and limit it to just official, quote unquote, discussions.
Okay, let's speak for a moment to open meetings and COVID-19. This question says, zone case records are still in the paper world. Working remotely for zone case answers and review is not feasible. Some zone cases that my office has involves 8+ folders within which each has packets of modifications. So how does a local zoning official work remotely without these case files?
Jesse, you want to take a stab?
I was hoping you would. I think,
This is the hot potato.
yeah, and I think the only thing I can think of is, as much as possible, making those files in electronic form. And we're trying to do that as much as we can. We keep the files electronically. When we have meetings, we share all of the documents with anybody who's on the meeting, put them up on the share screen. And that's all I can think of. I know that's not a good answer, but even in the age of COVID, there are some things that we need to be face to face. That's a tough one. Do you have a better answer, Jared?
I don't think I have a better answer at all, because that's a tough one, especially when you're talking about large quantities of materials. That's a really tough thing to try to, if you were to try to scan those in. I mean, that's extremely burdensome, and it'd take forever. I agree with Jesse. I think that and again, this isn't a great answer, but there's some things where I think we're going to have to have those face-to-face conversations, if at all possible. And that's going to be tough, because people's comfort levels are different. Different parts of the country are at different levels. And so that's going to be a really tough discussion when we go back. But at the same time, we still need to move things forward. We still need to meet, and I think for the most part, at least in the planning world that I've talked with people, most people have been understanding with FOIA requests and with moving development forward and that kind of stuff. But there'll be a time where things need to get done, and that's a great question. That's a very tough question. Our planners, we love face-to-face interaction. That's part of what we do. And so this has been hard for a lot of planners as well. And when you've got that kind of caseload, it really makes it very difficult, I'm sure. And I don't know how you would, to be honest with you. And again, that's not a very good answer, but I don't know how you would deal with that in an appropriate way. But that's a tough one.
Okay, next question. I think this one goes with the Signs for Jesus v. Town of Pembroke. When they it says, aren't schools a government purpose which are not usually subject to zoning requirements? I think it was in this case, they were looking to the school as an example.
Yes.
Right, okay.
Yes, that's so the person who posed this question is correct. What had happened was the church utilized under RLUIPA utilized the school Pembroke Academy as as a comparator, and the court said no, they're not comparable because of that exact point, is that they are not subject to the local zoning laws, much like the New Hampshire Department of Transportation. So that wasn't a good comparator. Neither one of them were for RLUIPA standards.
And they might have been talking about Hunt Valley Baptist Church also, because public schools were used in that case, and the court didn't seem to have a problem using public schools as a comparator. But I believe there were other uses that were also public assembly type uses that were allowed in that district as well. But that's a good point. And I think public schools in the Signs for Jesus case were actually a state agency. And I don't know what public schools are in Baltimore County. They might be a county level agency, which might make a difference.
Okay. Next question is in reference to the Redeemed Christian Church versus Prince George's County. This was the case to upgrade water and sewer to accommodate the larger congregation. Okay, so for this case, for the sewer envelope, did they indicate if sewer or water gallonage was available? Do they indicate if pipes are in the ground near the church's new property?
The case really didn't discuss that, no. Well, that's a great point.
Okay. Next one, meetings issue. So I guess going back to virtual versus in-person meetings, do boards of adjustments, BZAs, quasi-judicial boards, do they need to meet in person regardless of the state's allowance of virtual meetings?
Well, I think it probably depends on the state. I know in West Virginia that the boards of zoning appeals, I think we believe that they're subject to OGMA, so they would be subject to they'd be subject to whatever those rules are in the state. Yeah, I think it really goes down to what the statute or the executive order allows in your jurisdiction as to whether boards of adjustment or BZA, Board of Zoning Appeals, have to meet in person. Can one member of the BZA or Board of Adjustments meet electronically, whereas everybody else has to meet in person? That's, I think, subject to whatever the sunshine laws are for the jurisdiction.
Well, I think if you're allowed to do it, I think the question is, if you're allowed to do it, should you go ahead, allowed to go virtual, should you meet in person anyway? And one huge concern that we had, and I think could be a legal concern, is in West Virginia to say we're going to do the meeting on Zoom. That's all well and good, but if you're in McDowell County, West Virginia, you don't have internet service. You don't have good broadband. And so I think from a legal point of view, you have to meet in whichever way gives the public an opportunity to attend and be there. And if you're in McDowell County, Jared had to go to McDowell County several weeks ago because he can't have a telephone meeting really or an internet meeting. He had to be there in person. So to me, the key is, will the public be able to participate? And if you're not sure about whether the public can participate, you better do it in person, in my opinion.
Thank you. I think we have time for one more question. Let's talk about short-term rentals. The question says, with single-family zoning districts in jeopardy, how would that impact short-term rental regulations that were discussed?
That's a great question too. And I think they're referring to the fact that in Minnesota and a lot of other places, they're saying single family residential zones are a thing of the past, and we're gonna try to have more mixed use, mixed density development. And yeah, that's a good point. I think if you don't have any more single family residential, I think it would be very difficult to regulate based on the definition of single family. So I think you would have to use different strategies to do that. Although I still think, even though single family zones are not as prevalent, I think you can still word it so that if it is a single family dwelling within this mixed use zone, or whatever you call the zone, that we don't want it to be transient. We want it to be a more stable nonprofit residency. But it does make it trickier.
Okay, I think we're going to wrap up. Thank you for joining us. Thanks to the Mid-Atlantic Planning Collaboration, everyone that was involved in putting this series together. This, is the first of several that we have. So thank you. Be sure to join us for the next one. Head over to ohioplanning.org/planning webcast to register for all of our upcoming sessions. We'll also have a PDF copy of this session available on our webcast webpage. We are recording the session. We'll have it up on our YouTube channel here shortly. Just search Planning Webcast on YouTube, and our channel will pop up along with over 300 of our recordings. We have over 3,000 subscribers, so be sure to join us so that you get up-to-date information when we post our sessions. Don't forget to log your credits, 1.5 CM law credits for this one. And I think that's it. And thank you, Jared and Jesse, for joining us today. And everyone have a great rest of your week and a good weekend. Thank you.
All right. Thank you.
Thanks, everybody.